Okay, hi everybody. Just going to give this another couple of minutes till we start at 12:30 right on the dot. Okay, everybody, welcome. My name is Carolyn Meyer, and I am a partner at Strigberger Brown Armstrong. SBA is an insurance defense litigation firm, and we'd like to thank you for coming to this lunchtime seminar that we are calling Once Upon a Time, How to Weave a Compelling Narrative in Litigation. We will be going until about 1 p.m. There's a Q&A button at the bottom of your screen that you can use to ask questions, and we will deal with those at the end of the presentation, subject to the time that we have today. This presentation is being recorded, and it will be up on our website within the next day or two, so you can peruse it at your leisure. I'm going to be making reference to some slides, and certainly if you want a copy of those, you can email me for those. So we'll just get started. So most of the discussions and presentations that happen in our insurance defense sort of industry have a tendency to focus on litigation narratives that take place within the confines of a trial or a hearing. The reality is that most of the narratives we craft in litigation center around explaining or persuading a trier of fact, but they actually are stories that we tell one another. Insurance adjusters and lawyers, we tell these stories to opposing counsel. We tell them to the plaintiff or claimant themselves. We use these narratives in settlement negotiations, in casual conversations with opposing counsel or claimants, in mediations, case conferences, pre-trials. So today we're going to be focusing on crafting a litigation narrative outside of the confines of those rare times that we actually find ourselves in a trial or a hearing. Generally speaking, if you're talking about storytelling, every story has some basic components. Story has characters, setting, plot, a sort of narrative conflict, and then a resolution or a denouement. In litigation, we're bound by certain narrative components. For instance, we know that our main character is going to be the protagonist, who is our claimant or our plaintiff. We know that in some way, shape, or form, we have to confront the plaintiff's plot, which is, of course, the incident that gave rise to the cause of action. Today, we're going to be talking about the narratives that flow from damage assessments. And so we know we have to confront the narrative chronology involved in any kind of personal injury claim. Inevitably, we have to narrate the time before the incident, and we've got to deal with chronologically speaking, what flows afterwards. We know that the defense narrative or resolution of our story that we tell obviously has to involve containing or undermining or minimizing the alleged effect of that precipitating incident that gave rise to the cause of action. We know that in the stories that we tell in litigation defense, we know that we are, of course, in the business of advocacy. So the story is going to be one of persuasion. We're not here to tell stories that titillate or amuse. We're really here to advocate in an adversarial system. Another thing that is important to keep in mind is, of course, that whatever story we tell is bound by the parameters of the law in Ontario. With respect to damages, we're bound by causation. We're bound by the legal test of, but for this precipitating incident, what story could be told? And because of this incident, what story is to be told? Hewing to the parameters that we have enforced on us is what determines really our success or failure to persuade the other party. Now, it sounds trite to say, but the first thing to do is to craft facts. It sounds basic and easy, but it really isn't. And it's where a lot of narratives stumble right from the outset. Fact finding isn't objective. It's filled with values and assumptions and prejudices. By necessity, those of us on the insurance defense side have to approach our narratives with a lens of skepticism and distrust. That's our role in the adversarial system before us. But in litigation storytelling, despite our ultimate goals, it's important to lay a basis that's objective and grounded in evidence. We can't lose sight of the fact that we have to ground our stories ultimately in evidence. So as a narrative exercise, it's important to ground yourself in verifiable actions, behaviors, and events. It's important to remove the issue of motives or feelings. As a practical matter, how to do that is stick as close to the record as you can. Stay close to your transcripts, the medical reports, the clinical notes and records, the employment files. Tie every fact that you lay to something that is in evidence, and that should keep you as much as possible on track to building a story that can ultimately persuade. Your story will stumble and crumble unless you've got a strong basis of facts that can be tied to evidence. Now, once you have the facts, it's important to revisit the goal. What effect does the legal test that we have to meet and have to deal with have on the narrative story? From our perspective on the defense side, what it does is it creates two parallel narratives. And I make allusion here to the Gwyneth Paltrow movie, Sliding Doors. Narratively, there's one story, and that story is, but for the accident, what story could be told about this claimant, their function, their abilities, their needs, their activities, all of those things that create a claimant that has a claim for damages that can find recourse in our courts. You run that story parallel to the claimant who has sustained an alleged injury. Your goal is, of course, to close the gap between those two stories. You're trying to eliminate or reduce the effect of that precipitating incident on the narrative. Now, how do you actually do that? If you think about a narrative chronology, you can think of it as a road. Your job is to divert the narrative away from the accident. You need to stabilize the narrative so that the accident doesn't upset the life that our protagonist would have had but for the accident. Going a little bit further, how you actually do that is you need to look at the forces that act on the protagonist, both within and from outside. And this is the part of storytelling that is the most fun. It's where the story comes to life. It's where you've got a little bit of license to attribute motives. It's where the story is anchored and gets teeth and comes to life. From the outside, you've got to consider what intervening events are interspersed in that chronology. What has happened in that relevant time period? Did the claimant suffer other illnesses or stressors like divorce, death of a family member? Look inside at the claimant themselves. Give the protagonist, the claimant, agency. What behaviors do you see from them? Are they continuing to work, engaging in their hobbies, compliant or not with treatment, fulfilling their family duties? What characteristics can you imbue your protagonist with? What's their education level? What evidence do you have of challenges they faced in the past? What skills do they bring to the table? Use those narrative elements to fill out your protagonist. Then you need to ground yourself in narrative anchors. You've got to attribute relevance, weight, and motive to what you've fleshed out. That means when you're telling your story, you need to highlight what's relevant to move the story forward, focusing on your end goal. Coalesce around patterns and themes. Does your protagonist have a tendency to do certain things or behave in certain ways? An important thing when you're getting to this meat of the story is not to get carried away. Give the story air to breathe. And what I mean by air to breathe is you're never going to know as much about the claimant as they know about themselves. So don't box yourself in with assumptions or conclusions that may ultimately be factually wrong. That's going to undermine your credibility as a storyteller. You can't assume that you have the full picture. So give your story some breathing room so you can pivot if you need to. Makes you more agile, and ultimately it will give you a better story that can adapt to circumstances. Now, when we talk about the delivery of this story, we talked at the beginning about how ultimately, of course, we always make recourse to the trier of fact, the jury, the judge, the adjudicator. But again, we're focusing here on the story and the narrative that is told between the parties. And an important narrative tool is to tell your story through the eyes of the decision maker, of the trier of fact. So employ the voice of the juror as narrator. Your story should be told as a third-person narrator. Now, the reality is everyone in insurance is always making recourse to what the jury will think or decide. The fact of the matter is that jurors are an unknown. And so use that to your advantage when you're telling your story. Imbue that blank canvas of the juror with the ability to make conclusions and determinations. The jury's nothing but a vessel for you to get your point across. Using the jury as the narrator of your story is also a tool to distance yourself. When you make conclusions that might displease the claimant, you put them through the lens of the juror. The juror can have a distinct life and lens, and you can give that power. You control that narrator. So when you're narrating through their voice, build them up so they can sustain the themes you want to convey. You want to stay away as much as possible from taking on the voice of the claimant or using your own voice. It's difficult to control the claimant's voice, and it's opaque because we can never know, again, the claimant as well as they know themselves. Now, when we think about the juror as narrator and how we tell the story through their lens, there are three basic themes and lenses and points of view that we generally employ in litigation. They're by no means exhaustive, but they do give you an idea of how narrative can be crafted differently depending on the case facts and the issues that are in dispute. I call them the juror who looks down, the juror who looks out, and the juror who looks up. Put another way, there's the jury that will scold the plaintiff, the jury that will scare the plaintiff, or the jury that will empower the plaintiff. And I just want to actually ground this in some concrete example. So I've just set out here a few basic facts about a run-of-the-mill chronic pain type case. We've got a 30-year-old, she's got a kid with some special needs, she's divorced. She had a history of working as a PSW and in retail. She has had a bit of chaos in terms of her living situation. She was involved in an accident about 1.5 years ago. No objective injuries. She's got a chronic pain diagnosis from a family doctor. She hasn't been that compliant with treatment since the accident. At discovery, it was hard to nail her down on admissions. She was a bit evasive and meandering. Since the accident, she's lived with her sister and went to go stay with grandma in Saskatchewan. She's a bit scattered all over. So this is who we've sort of got to work with and the facts as we've laid them out. If we take the perspective of the juror as Big Bad Wolf, the story we can tell the claimant is to say, you know, this jury is going to see the facts before them. They're going to see a claimant who didn't sustain any fractures or any other objective injuries, who continues to be the primary caretaker for a child who has a lot of needs, who isn't going to treatment. And that juror might shut you out completely. Those jurors might look at the case from the aspect of gatekeeping, and they might say to themselves, you don't pass that hurdle. That's a big risk for you as a plaintiff. You need to be worried about what that jury sees and thinks when they look at the facts of your case. If we wanted to look at those same facts, but use a jury that is a scolding jury, like the judgmental stepsisters in Cinderella. The recourse to the scolding jury might be to look at those same facts and tell the plaintiff, When the juror looks at a claimant who has not sustained any injuries that they themselves can see, they're going to evaluate you in respect of their own experiences. And you can expect that the people on the jury, they get up to work every day despite their own aches and pains, and they continue on and plod through. And so we've got to think about what the jury is likely to do when confronted with someone who hasn't made efforts to return to work and hasn't made any efforts to pursue treatment. From our perspective, it appears that the jury might not sympathize, might be upset at the idea of awarding damages in circumstances like this. Then we can use those same facts and employ the voice of a jury that empowers the claimant, the fairy godmother juror. In using those same facts, we can spin a narrative through the voice of the jury that says, this jury sees you, who has been a single mom, who's managed to take care of your son on your own, who has a history, a work history in physical jobs, who since the accident has managed to up and move to keep a roof over your head. And they're going to think to themselves, this is a lady who can find her way on the outside of this accident. They're going to think that you will rally, that you will get better. And as a result, your damages are concomitantly reduced by virtue of the faith that the jury is going to have in you to come out the other side of this incident. These are just narrative examples of how we can use a different lens to get to the same results. Again, we can only do what we can do in litigation because of how we're bound by the law, the protagonist we're stuck with, the goals that we have to achieve. And so let's use as much as possible the tools that we have available to be creative, depending on the claimant and the parties involved. So this presentation is nothing more than a jumping off tool for you to be able to think about how to really tell a story that changes the dynamic between the parties and hopefully helps come to resolution. So that's basically the gist of this. And I'd like to just set out if there are any questions or comments. And I would like to also point out that one of my lovely colleagues, Shalini, is going to be doing a presentation on January 22nd, same time. So if you'd like to tune into that one, I know it will be great, because if there's one thing I know, it's that Shalini is a good storyteller. Okay, I'm not seeing any questions. So I think that that will be the end of things for today. And we'd like to thank you once again on behalf of Strigberger Brown Armstrong for tuning in with us. Have a great rest of your week, folks.